A very good afternoon, friends. It gives me immense pleasure to welcome you all to today's webinar on contrast and criticality of deemed UPSI under PIT and its disclosure under LODR. This is our 95th webinar in our efforts for knowledge sharing, which we are will continue. Thank you for all joining in our journey and encouraging and motivating us in our knowledge sharing endeavor. Friends, recent adjudication orders of Securities Market Regulator SEBI under PIT regulation have incentivized the discussion on a host of issues in Indian listed entities. Some of the key issues resolved are when an information is to be deemed an UPSI. As you are aware, that as per SEBI Regulation 30, SEBI has LODR regulation, SEBI has insider trading. So insider trading, they restrict that no insider should buy if he possesses UPSI, unpublished price sensitive information. And then simultaneously, they are saying any price sensitive information or any information which is material, you have to inform to the stock exchange immediately under Regulation 30. So today we want to discuss that when an information is to be deemed an UPSI, when an information becomes concrete and credible for disclosure, because one is information, second is when it is concrete and credible. Whether the interplay between PIT and Regulation 30 of LODR regulation pose risk of double whammy, since premature disclosure may be perceived as inducement, which is punishable under Securities Law. Friends, the objective of the webinar is to discuss and deliberate as to when an unpublished price sensitive information can be considered credible and concrete enough for disclosure, the nature and extent of listed company obligation to issue clarification on media reports, and the practical issues and risks that entail when dealing with disclosure under PIT regulation, as well as the way to mitigate them. We have today galaxy of experts on the subject. First, Ms. Anjali Agrawal, she's partner head, capital market services, corporate profession. Then we have Manoj Kumar, partner head, M&A and transactions, corporate profession. Mohini Bashne, partner head, ESOP and insider law services. Ravi Prakash, associate partner, corporate profession. Ruchika Sharma, she is also associate partner, looks after the open offer and various transactions in the company. Friends, the main issue of today's discussion is that recently we have seen so many cases of the SEBI has passed, and they have imposed penalty as well as warning to the various authorities, and then there are some informal guideline also where they have explained that what is the meaning of the Regulation 30 and when you have to inform. Now the point is, when you are doing any transaction, the transaction is not taking place in day. First, somebody will give interest. Other person will accept your interest. Okay, yes, we can do. Then there is a discussion. Then there is a negotiation. And when they are agreeing on the negotiation, then they will start the due diligence. Subject to the due diligence, they will further negotiate. In the due diligence, there are two situations will arise. One is either something which they have disclosed that is a deal breaker, and something which is where the price has to whatever price they have quoted and whatever the price they have agreed, it will reduce. And there is a possibility also, even doing all these things, there is a possibility that deal may cancel. They may both the parties not agree and they have cancelled the deal. Again, they are starting negotiation. And then we have seen so many transactions where second time also they have not agreed and ultimately deal has cancelled. And after a few months, again they have come out and then the deal is finalized. So the question is that in this scenario, and this is with every case, because no case is not a over the shelf something we are going and buying. You are seeing the rate and purchasing. It is a negotiation. It is so many things has to take place. Due diligence has to take place, and various aspects has to take place, then transaction will complete. So now the question is, at what stage I should give information to the stock exchange under Regulation 30? I'm not talking about the materiality. I'm not talking about the other information. I'm talking about the anything which you have to report to the stock exchange. This is the stage where you have to do this. Now, regulator sometime asking that you should have given this information, but the question is, if I'm giving information and my deal is not taking place, then what will happen? Because something which is good, you are acquiring something and the company will grow, the market will react, and market react positively or negatively also. Sometimes you are buying something, like you have seen the bill, he has purchased, Musk has purchased Twitter, and their Tesla share has gone down. So that may be the impact on anything. So issue is that when this information is reliable, concrete, and ready to give to the information. Now, there's a disputed questions, disputed issues, and disputed point. And here there is a one case which we were handling, and in this case we were arguing that they were saying there is a transaction out of India, and in the transaction there are so many times it has come that transaction has failed. They have appointed the legal advisor, and then things were going on, and suddenly they have agreed, and after some mitigating factors, they have accepted the deal. Question is, we have argued in this case that this is the same situation like the MD of the company is in ICU, and it is a material information because MD is the important person, and then doctor is saying, boss, we can't save him now, just pray. Should I give information? After some time, he recovered and he is doing okay. Suddenly something has happened, and again there's a problem. So this is the same situation with the transaction also. It is like up and down, up and down. So at what time I should inform? So this is one area where we are facing problem, and we want to discuss this threadbare. Second aspect is insider trading. In insider trading, some information, because all these people, those who are involved, that is very clear that this information which is with these people, few people, they can't trade shares. But if the information is not material, information not UPSI, can they play in the market? Can they purchase and sell in the market? So all these issues we will discuss today. And anybody has any question, please give it to us. We will give answer. So the program structure is like this. First, I will request Mohini. She will discuss about the PIT regulation related to this aspect. Then I will request Anjali to discuss about the public disclosure under Regulation 30 of LODR. And then Ravi will discuss interplay of LODR and PIT, because this is the main crux. And it is a main issue today. And then Manoj and Ruchika will be the participating in question answer, and their point, any important point which they think after the three speaker, they can speak. So we are starting with Mohini. Mohini, please share the PIT regulation aspects connected to this today's topic, and then Anjali, and then Ravi. Over to you, Mohini.
Yeah, thank you, sir. Good evening to everyone. So I'm just sharing my screen. Yeah. So today I'm going to take you to, I want that we should walk through first that what exactly the insider trading is. And in the insider trading, the main subjective discussion is the UPSI, because entire insider trading is based on the trading on the basis of the UPSI information. So what is insider trading and how it is walked through UPSI, and then how the UPSI become public. So today we are going to cover on this aspect first. So what is insider trading? Definitely insider trading is the trading in the securities of a listed company. All we are aware of that in the PIT, we are covering the trading in the securities of a listed company by any person who may not or may not be managing the affairs of the company. So he is not that he is an internal person to an organization. He might be a consultant. He might be from any other means. He might be aware of what in the organization the information is prevailing based upon which the trading has been done. So any person who comes to or who has a knowledge to the affairs of the company, and while in possession of that particular information, which is of sensitive nature and is of UPSI nature, which we say they trade, then it becomes an insider trading. So the trading in the possession of the UPSI by any person, it becomes an insider trading. When we talk about the UPSI, which is a subject matter of today, so what is UPSI first? So as per the law, they have defined the UPSI as any information which is relating to a company or its securities. So it's not only the company. If any person is aware of about the securities, that means which are tradable securities at the stock exchange, those information either he comes to the knowledge directly or indirectly, or about the company or the securities on a directly, if it is affecting or indirectly affecting the company, and that information is not generally available, and if it become available, it can materially affect the prices of the shares of the company, that information is of UPSI nature. So they have not given any specific uh, list of items which can be an UPSI, but they have given a identification of the any information based upon these three parameters, that the information becomes the UPSI. They have given in the law the 5 examples which they deem it's of an always be an UPSI nature, like the financial results. So all the quarterly, whether it be quarterly, audited, unaudited, till the time it becomes public, they say that it is a UPSI. And we all are aware of, because of this financial results, UPSI nature, the trading window of the company in every quarter get closed for all the designated persons in the organization. So the financial results, that means the financial parameters, have been considered as the UPSI, first and the foremost UPSI. The second, it comes to when it comes to the declaration of dividend. So because dividend, ultimately you're returning something and you are giving some value to the shareholders. So dividend information, they are again treating that it will be of UPSI nature, irrespective of whatever the quantity you are declaring. Then any change in the capital structure, you're coming out with your IPO, FPO, your preferential rights, bonus, any kind of change in capital structure, even it includes split and all, it will be deemed to be in UPSI. And the changes in the KMP, because key managerial persons have a very important impact on the decision making of the company. So any change in the KMP will also be deemed as in UPSI. So these are the few examples. They have not said that these are the only UPSIs. Other things are not UPSI. They have given the parameters for the other kind of activities and the informations which can be of UPSI nature if they pass all these three tests. Now, if we go to that, what other kind of information can be of UPSI? So generally we talk about that like any substantial increase or decrease in the sales, that will also we can treat as an UPSI. And because it's not known to the public until and unless your financial results will come out. Then any stressed assets or NPAs have been created, or your any distressed assets are being created, that can also be treated as an UPSI. Credit rating, any product launch, which is when it comes to the market, it will going to impact the image and the branding of the company. Any capacity addition, this can also be treated as an UPSI. Then it comes to then if the listed company is going for any delisting of its securities, then it becomes again an UPSI nature. So all these information may be of UPSI nature, but it entirely depends upon that what will be the so the company has to judge that at which we can say financial figure or it is going to impact, which can ultimately materially affect the price of the company. For example, in case we talk about the capacity addition or so. So whether this capacity addition with a very small amount as compared to the total turnover of the company, if it is very minimal one, the company may treat okay, it may be not be in UPSI, but if it is a any percentage, they can decide okay, if it's a 5% or 10%, then the UPSI can be deemed for. But it entirely depends upon the management, because they have to find out that with which kind of information, if it comes in the public, materially affect the price of the company. So the company has to judge on these three parameters about the UPSI. Now, when we decide of an UPSI, so the important thing is to understand is what is the UPSI period. So nowadays, all the cases when we talk about in the PIT, they all are talking about the UPSI period, because the time period which is of UPSI period is the important period wherein any person who has this information can't trade. So this UPSI period we talk about that it starts from the day. So when it starts, so generally it takes into consideration that whenever any discussion starts in the management, wherein we think that it's going to have any concrete or credible shape, from that period it starts. So any discussion when you are appointing, for example, you are discussing any event you want to come out in the company, and you have also appointing any consultant in your organization. So it can be deemed that from that very period the UPSI has started. Now, up to what date this UPSI will remain as in UPSI? So this is the UPSI period. So when this UPSI period ends, the UPSI periods end when it either be officially disseminated by the company on its own website or on the stock exchange intimation you have done. So at very day, it is deemed ki yes, your UPSI, you have made it public, it becomes the UPSI period gets over. Or any kind of a press release you come out, then it becomes again that you have disseminated to public from your side, then it becomes a public information. The information, if it is not being disseminated by the company, and if in any news item this information is traveling, then it's not deemed that you have done the that UPSI period is ended. The company can't take that plea. The company has to either deny that plea or has to confirm that thing. Then it becomes the end of this UPSI period. So this is with respect to when you disseminate that information that yes, this transaction is going to happen, then it becomes the end of that UPSI period. But many a times in the organization, not necessarily that whatever the discussion starts in the organization, it will take a concrete shape. So it can also be discarded. So when it gets discarded, then also it becomes the end of the UPSI period. When we talk about the UPSI public dissemination, then in the as per the PIT, there is a one code and the policy which the company need to maintain, that what they are adopting as a practice for following and following the for which they follow for disclosing the this UPSI to the public. So we talk about the codes. So what all codes the company need to frame is code of fair disclosures by the listed company, code of conduct by the listed company, which is for their designated persons, and similarly there are other codes for the intermediaries and fiduciaries which they need to form. Out of these codes, the main code which deals with the in making the information public of the UPSI is the code of fair disclosures by the listed company. And if you, as you all are aware of that, as per the PIT code of PIT regulations, this code need to be displayed on the website of the company as well. In this code of fair disclosure by the listed company, what exactly the company covers is, it gives a insight on first that what the governance practice of the company is with respect to the handling of the information within the organization and its information to the public. So this code is formulated by the board of directors of the listed company, and it will be and it is a framework and the policy for fair disclosure of event and occurrence that could impact price discovery. So this is the main important thing in this code, that it should be it covers those practices which the company follow to disseminate it in the public. So the important content of this code of fair disclosure is that what is the principle of avoidance of selective disclosure and the universal dissemination of information company follow. So company has to give that yes, what practice they follow with respect to this dissemination of information. And the company generally writes that when the information becomes credible and complete, immediately the company has a practice to inform it to the stock exchange and through press release or through the information through or to the its own website. And if we aware of that, all the transcripts of the whatever the investors discussions are there, that is also being displayed on the website of the company. So these are the practices which are being followed, and it has been clearly written and adopted by the companies in their code of fair disclosures and policies. So this is the policy which the company adopt, and the company follow it, because it's a practice and it's a governance practice. So the company is following these practices as well. So here the journey of the UPSI ends, that how the UPSI originates, what the UPSI is, and how it gets disseminated to the public, and what the practice the company follow. It is also be aware of by all the public, because it is being displayed on the website of the company. Nowadays, many case laws are coming wherein the SEBI is deciding on the UPSI period. We have covered few cases here. So in the ADF food matter, the SEBI has mentioned that in this case, the UPSI period starts from the very date when in the board meeting, ADF food has first considered it as a buyback decision, but buyback only the buyback discussions has been made in that May 21st, 2016 meeting, but nothing has been decided that yes, the buyback need to be the buyback will be done in the company. So at that point of time, no intimation will be given to the stock exchange. But again, in July 27, 2016, again they have considered this buyback buyback decision in the board meeting, and at that time they have informed to the stock exchange, yes, they are going ahead with the buyback decision. So in this case, in this case of ADF food, the SEBI has decided that yes, from the May 2016 till 27th 2006 July 27 this is treated as a UPSI period in this case. When we talk about the Varun Beverages case limit, in the case of Varun Beverages case, in this case also, the company is going for the strategic partnership. So the strategic partnership meeting has started being taking shape in the month of December 2017. But finally, when the things and transactions get concluded, company filed its press release on 4th January 2018. So in this case also, the SEBI has considered that this period is from December till January. It has been treated as the UPSI period in this case. When we talk about the recent case of Reliance Industries, in this case also, with respect to the investment of the Geo sell stakes to Facebook, in that case also, the news were in public in the market in the London newspaper on 24th of 2020, March 24th, but the company has made its formal announcement only in April 2020. So they have made this period is also an UPSI period, because in the March the company has neither rejected this information of the deal and neither has accepted this is a deal. So this period is also being treated as the UPSI period in this case. So thanks from my side. So I have make you aware of that how this UPSI has starts and ends through the public dissemination. So over to you, sir, please.
Okay. Thank you, Moini. Thank you for giving the insider trading connected to this topic. So friends, I will request now Anjali to share about the LODR, when to inform, and then Mr. Ravi for main issue which we want to discuss. Yeah, Anjali.
Thank you, Pawan sir. Let me share my screen. Is it visible?
Yes.
Yeah. Good afternoon, all. This is a very interesting topic and is a topic which remains very close to each one of our hearts when we talk about Regulation 30 disclosures or when we talk about the insider trading regulations. And the way Mohini has explained the insider trading implications, what an insider trading means, what exactly who all fall within the ambit of an insider, and what is the insider trading period. Now the most important phase comes as to when to inform this information to the public at large, to the stock exchanges, and then the dissemination thereof to the public at large. So Regulation 30, listing regulations are no new regulations. They have been in place for about 7 years now, but still Regulation 30 acts as the most tricky regulations of the entire set of regulations, wherein the confusion is when an event is supposed to have occurred and when to make a disclosure. So Regulation 30 talks about that events or information which in the opinion of the board, they have mentioned very clearly, the opinion of the board are material, are needed to be disclosed to the stock exchanges. Certain parameters have been defined in the regulations to determine the criteria for materiality, which include the omission of an event or happening of an event, wherein if it becomes publicly available, there will be a discontinuity or alteration of an information which is already there in public, or there can be a significant market reaction if the said information becomes public at a later date. If the above conditions are not applicable, then again, in the opinion of the board, if any information which as per the board is material, public has a right to know about it, a disclosure is needed to be given for the same. Along with that, the board has to authorize one or more KMPs for determining the materiality. The company has to prepare a policy for determination of materiality of events, and Schedule 3 of the list regulations is the main regulation. It contains an illustrative list of events which are needed to be disclosed. The said schedule is divided into two parts. Part A is mandatory items, which in spite of whatever happens, they are considered to be material and are needed to be disclosed, wherein no materiality policy is needed to be applied. But part B, which is the main confusing area which arises for many of the professionals, wherein the materiality policy is needed to be applied and are needed to be disclosed if they fall within the ambit of the company's materiality policy. So when a disclosure is needed to be made, an event, if it falls within the ambit of part A, as I told you, a disclosure is needed to be made without thinking that whether it falls within the materiality policy or not, it is needed to be disclosed. But if it falls within part B, then we have to apply the significant price sensitivity test on it, or the change or discontinuance test on it, and the materiality policy on it. And if the impact is significant, then a disclosure is needed to be made. If the impact is not significant, then a disclosure is not needed, may be avoided. Now, part 3, as I told you, comprises of two sets, part A and part B. So part A talks about, comparatively, it's simpler for the companies when the list has been mandated by the regulator. They all know that we have to disclose. So acquisitions or agreement to acquire, issuance, forfeiture, consolidation. I'll not be going into too detail about the part A events, revision in ratings, outcomes of the board meetings, agreements, frauds, or arrest of the promoters or KMPs. For example, in the beginning, Pawan sir gave an example that the promoter or managing director of the company is in ICU. Is it a material event or not? So it is a material event and should be disclosed. Now, with regard to the first item mentioned in part A, there appears some confusion at times in the minds of the companies when, for example, acquisition. So the question that comes to us many a times is, I'm incorporating a wholly owned subsidiary. Am I required to make a disclosure? The answer to this would be yes, because you are acquiring more than 5% in a particular company. Now, the second question that comes is, I'm making further investment in my wholly owned subsidiary, wherein there will not be any change in the shareholding. So still, am I required to make a disclosure? I would want these questions to be answered in the Q&A session better. The third question, which at times comes to us, is I have a subsidiary. My shareholding has fallen in the company because the subsidiary has made an allotment to an outsider, and the law says a change of 2% is to be disclosed. Change means whether a positive change or a negative change. So again, am I required to give a disclosure to this effect or not? Then change in directors, KMPs, auditors, change in independent directors, change in RTA. These things are needed to be disclosed mandatorily. Resolution plan, one-time settlement with the banks, the outcomes of the AGM and EGM amendments in the memorandum and articles. These things are mandatorily required. Schedule of analysts and investors meets, audio recordings and transcripts of the calls. These are any initiation of the forensic audit is needed to be mandatorily disclosed. Now coming to the part B events, wherein the materiality policy is needed to be applied. These are the items which are on a daily basis, we receive some call or the other from our clients as to the clarity whether a disclosure is required to be given or not. Commencement, postponement in commencement of commercial production, change in general character or change in business, capacity addition or product launch, or awarding or bagging of a contract or award. Now, with regard to this particular item, a practical question that a tender has been given to me for initiation of, for beginning the production of a particular item. But this production will initiate upon receipt of various government approvals. For example, change of land use, for example, the approval from the pollution board, which may happen, may not happen. So if I give this disclosure at the initial level itself, and I don't get those approvals, what do I have to do? Do I have to give a disclosure? So these queries remain with the listed entities. Then agreements, including loan agreements, which are binding and not in the normal course of business. Herein again, if the promoter is giving a loan to the company, and is it required to be disclosed? It's an unsecured loan, is it required to be disclosed? Then disruption in operations due to natural calamities, that is okay. Effects of change in regulatory policies on the company, litigations and impact, fraud, default by the directors. Now the promoters or directors have entered into a settlement with SEBI. So is it required to be given? The listed entity is not involved in this transaction. It was the directors or the KMP of the or the promoters of the company. Is it required to be disclosed? The details with regard to ESOP or ESPS schemes of the company, giving guarantees or indemnity or becoming of surety to the third party. I feel that this should be an item of part A and not part B, because if as a listed entity, I'm giving the guarantee or indemnity on behalf of some third person. So that this is a very important aspect, and which should be disclosed. That means the third party is very close to me, and I have full confidence in that third party. And that is why I'm giving that disclosure. Granting, withdrawal, surrender, or cancellation of any of the licenses and regulatory approvals. This again should be an item of part A and not part B. For example, if I am an NBFC and my registration with RBI is suspended for any reason, this is a material event, whether it has an impact as per my materiality policy or not, it has to be disclosed. There are certain other live examples which come to us. For example, if any regulatory body issues a information seeking letter to the company, should this be disclosed to the exchange at the very first level? because there is a possibility that this letter may get resolved. This info needed may get resolved by giving a reply, or may even turn up into a as big as thing, a forensic audit. So still, at what level am I required, as is the company required to disclose to the stock exchange? Because it is not a show cause notice, it is only asking information. Then criteria for framing of materiality policy. And this is the most vague thing, and the regulators need to frame concrete terms as to what all should be there in the materiality policy. To explain why I use the word that there is a confusion, we analyzed the materiality policies of a few companies, wherein few of them were top-notch companies, few were level 2 companies, tier 2 companies. Every company has a different materiality policy. For example, this is the policy. We have not used the names of any of the companies. This is the policy of a company which talks in a very, very vague term, omission of an event which is likely to result into discontinuity or alteration of an event. With these provisions are there in the listing regulations as well. They have not defined anything else. This is the policy of another company, wherein it talks about A, B, C are the same as given in the listing regulations. Then they have given an illustrative list of items which have to be disclosed to the stock exchanges on the basis of application of materiality policy. And the other list talks about the events which will be mandatorily disclosed to the stock exchanges. Herein again, it is a total contrast to the first company which we discussed. This is another company which talks about certain qualitative parameters. Qualitative parameters are the same which are given in the listing regulations. Then they have spoken about some quantitative parameters as well, wherein the value involved or impact exceeds USD 500 million or 10% of the net worth. This again is not defined in the law. So every company is following their own practices. This is yet another company which talks about the quantitative factors, quantitative criteria in terms of 10%, any transaction exceeding 10% of the consolidated gross turnover, 10% of the net worth, and the qualitative parameters which are given in the listing regulations. Another company which talks about all the different items which are given in part B. Every transaction, every item has been given a particular percentage. Commencement of production, 5% impact of more than 5%, product launch impact of more than 5%, awarding of any contract consideration exceeding 100 million in a financial year, so on and so forth. So every company is following a different practice. So unless this particular policy is made in concrete terms, there will always remain a confusion as to when to give a disclosure. If the companies can decide upon their policy in a very clear-cut way, to my understanding, the confusion as to when to make a disclosure, what to disclose, will get resolved to quite an extent. This was my take on the listing regulations, Regulation 30. Thank you.
Okay, Anjali, thank you very much. Now I hope that the point which Anjali has raised is clear. So now issue is that Mohini has showed us the insider trading, that what are the issues, and Anjali has given the LODR. In LODR Regulation 30, what we have to do. Ravi, now your turn. Now, yes. These two ladies has given you their side of story.
Yes.
But the point is, when information is credible, when I have to inform, when it is material, if my information is not material, should I not inform? When is a material, what is the materiality? Because that is always dispute. So they have given that every company will decide materiality. So if the materiality, everybody is deciding on their own, then what it means? Regulator may say, because that is also not exempted, that whatever you are deciding, it's correct. You may decide less, you may decide higher, which regulator may not agree. So you have to work out. So please come out and tell us what is the best solution and what issue relating to both the issues and how to harmonize this. Over to you, Ravi.
Thank you so much, sir. As I say, this insider is just like the tip of iceberg. 1/10 remains on the surface and 9/10 remains submerged in the ocean of abyss. And the more you read about it, the situation is that more convoluted it becomes. Unless until you sit on a table, put all the pieces of puzzle and set them together and see the holistic picture. Since you have indicated there is some sort of interplay, and because that's also the theme, let us start with what are the similarities in LODR and PIT regulations, and whether at all there is any similarity or not. And if there are similarities, to what extent there is an interplay, and what is the consequence? And then, if at all there is an interplay and there would be consequences, how to go forward, what the corporates and regulator have done on their part to harmonize this, and what is the way forward. That is broadly the index of how we would be moving. Now, if one considers carefully the definition of unpublished price sensitive information under PIT regulation, it usually is a debate that there is something called deemed UPSI. I'll come to this definition later on. Let us see what is a deeming definition, how the legislature frames a deeming fiction in law. For that, we must consider Regulation 30, Sub-Regulation 2. It says, events specified in Para A of Part A of Schedule 3 are deemed to be material events, and listed entity shall make disclosure of such events. Here, it is very clear on a plain reading that there is a deeming fiction at play. One does not have to apply any kind of external factor to consider whether we should disclose it or not. The clarity is there, list is there, and it is said that these are deemed to be material, so you disclose it. I shall come to sub-regulation 4 of this regulation 30 a little later on. Now, if we come to unpublished, the definition of unpublished price sensitive information, it says means any information relating to a company or its securities directly or indirectly. And these are the three elements which Ms. Mohini Varshne has very beautifully explained. These are three ingredients. All of them must be present. Second is that is not the information, such information should not be generally available, and which upon becoming generally available is likely to materially affect the price of securities. So one part is the definition of UPSI, which also lays down a sort of principle. Whether this principle is sufficient for people to determine what is UPSI is a different question. We'll also see that. But it lays down some kind of a prima facie principle. What is interesting is that in the later part, this definition says that and shall, ordinarily including but not restricted to information related to the following. So there is no word deemed. They only lay down an indicative list. The first aspect is whether out of this list, there could be some information which is not UPSI. I feel yes, but that should be proven by the person who is trying to prove a case that this was not a UPSI, because it says ordinarily, but it is not irrefutable. It is a rebuttable presumption, if at all it's a presumption. Now, in LODR, we read in the definition of UPSI that the test ultimate is that there should be a likelihood of materially affecting the price of securities. I remember long back there was a discussion on the marketplace in Supreme Court. And it's a very old case, although it arose also under Securities Contract and Regulation Act for its scope and ambit. So the question was, what is the market? So the Supreme Court said that, actually, we would not test that whether there exists an actual market where buyers and sellers interact. We would see the aspect of marketability. And that is what will determine whether there exists a market or not. So in UPSI also, the test is not to actually see whether there is an impact in securities on the price of securities or not. The test would be, what is the likelihood of such information upon becoming generally available materially affecting the price of securities? Now, on this very point, let us go back to LODR and see what LODR says on this one. Part A is done because para A of Part A is done because that is a deeming fiction and disclosure has to be given. But what about Part B? For Part B, principles are laid down under Sub-Regulation 4. And there are 3 principles. These are also indicated. I'm not concerned with the other 2, but the principle laid down in subclause B of this Sub-Regulation 4. The omission of an event, and it reads as, the omission of an event or information is likely to result in significant market reaction if the said omission came to light at a later date. So these are the criteria which should be considered by a company for determination of materiality of events and information. And it says that if there is a likelihood, and again, I'm stressing upon this terminology because again, there is an element of likelihood. The information is likely to result in significant market reaction if the said omission came to light at a later date. Now, if one reads the definition of UPSI and the principles laid down under Regulation 30, it becomes clear that there could be situations where an information which is material under LODR might also be an UPSI. If it has triggered the materiality on the basis of this clause. That if it is disclosed, if it is not disclosed, then later on it would create significant market reaction. What would be market reaction? Market reaction would always result, and in most of the cases will result in some kind of interference at the demand end or at the supply end. And if that happens, there is a direct correlation with the price. So therefore, there is an umbilical cord, or you may say there is a common thread between UPSI, this PIT regulations and LODR regulations, particularly the definition of UPSI and Regulation 30. But conversely, every material information under Regulation 30, even though it is listed in para A, is not necessarily a UPSI because the test of UPSI is one, whereas for the test in LODR, particularly for para B, is threefold. The test for UPSI is one, that there must be likelihood of materially affecting the price. So if that parameter is met, it would be a material information as well as a UPSI. To put it simply, is that every UPSI, because it will materially impact the price and would thus qualify this likely to result in significant market reaction, would be material. So that means every UPSI, every information which is classified as UPSI can be called as material. But every information which is recognized as material under LODR is not a UPSI. And I've tried to explain the lines of reasoning as to why I say so, why I opine so. This is the first part. Now let us see what SEBI has to say on what constitutes a UPSI. So I'm reading a paragraph, and this should give a clarity on what should be considered as UPSI, but I assure you this will not clear all your doubts. A lot is left to be wanting. The para reads thus: there are a host of factors that determines the existence of UPSI. Number one is the nature of transaction. Number two is the progress of the discussions. Number three, outcome of various stages of negotiations. Number four is the increasing probability of transaction going through, and so on and so forth. Therefore, for each matter, the entire facts and circumstances of the matter must be examined without giving undue weightage. And I lay my emphasis here, without giving undue weightage to any one aspect or facet of the matter before arriving at the conclusion of existence of a UPSI. Now, the excerpt which I read is from the order in the matter of Biocon. And those who have been following securities market, they must be aware that in recent past, there was a deal of Biocon with Sandoz, which was taken up for investigation by the Indian Securities Regulator. And ultimately, one of the key managerial personnel were found to be in violation of some provisions, and then actions were taken. But because there were a lot of nuances involved and a lot of defenses were taken, the order captures very beautifully the mind of regulator, if not the crux of the regulation, at least the mind of regulator. In this matter, now let us not discuss about what has happened recently. It is a buzzword what has happened recently in the securities market, the recent insider trading cases where liability has been fastened based on newspaper publications, whether or not a newspaper is an evidence for something, I mean, if you go by Evidence Act, newspapers are at best hearsay. They could be because they quote as per sources. And when the parties say that the contract was not credible or concrete enough so that we could have decided that whether to disclose it or not, because in the last part of this session, I would be throwing light on how a reckless disclosure, a premature disclosure of information can also lead into serious consequences of being charged with fraudulent and unfair trading practices. One needs to remember that inducement is one factor which Securities Market Regulator always sees and examines, that if any act was done to induce the investors or to cause inducement in a particular script or in the market-wide or selective scripts, it is a fraudulent act. And a misleading information or misrepresentation is certainly one of the elements of inducement. So the situation is of double whammy. When to disclose, whether to disclose, and on the top of it, the most distressing question. One does not know, as on today, if there is a transaction ongoing, one does not know on the first day itself. And this is a fear which many must be facing in their hearts, that whether on the first day they are in compliance with law or not. Forget about going forward with transaction and thinking about disclosing it later. Even before starting a transaction, there must be fear in the hearts that the regulator might see us in contravention of law, because precisely there is no guiding test is on what particular stage I should come and disclose. So this is about the connection or the so-called interplay between LODR and PIT. But I believe that in objectives, these regulations try to monitor or try to regulate two different aspects of the market or the market infrastructure. LODR, while it deals with, and I'm not giving the entire exposition on what LODR, what are the statement of objects and reasons for LODR, but little hint on it. It deals with the necessity of disclosures, governance, and compliances. And so it is found on those three anvils and touchstones of governance that for the sake of transparency, one must disclose. Disclosure must be widely disseminated, and the timings and the nuances related to it. And at the top of it, the compliances, the whole set of compliances that a listed company needs to undertake. So far as listed scripts are concerned. PIT, on the other hand, is a peremptory law, is a negative law, is a law which restricts. It's not an enabler law. So if you say it is the other side of governance, which says that you please do not let this information or the insiders to undue or unfairly advantage out of the asymmetry of information. So this asymmetry of information is the key on which insider law has been developed. And you would see that it is all across the world. Every securities market structure must be having this insider protection, because without this protection, no securities market structure can exist. So this is on the importance of having PIT and a robust PIT. The real question is whether this regulation, which seeks to preserve the sanctity of market, the integrity of market, the confidence of investors, should result in consequences which can be avoided or which would cause anomaly or unnecessary hardship for people who, due to the law being so convoluted, have gotten trapped. The answer is no. There can be no objective. The laws are not made with objective that you must punish or you must bring it to logical conclusion on one pretext or another. The laws are there to establish and preserve what is at the heart. It means what is at the objective of the law. It's asymmetry of information. It tries to curb down the asymmetry of information and to ensure that no one unfairly enjoys it. But then one must see the surrounding infra of laws. For example, if a company which is coming out with a transaction, which announces about a transaction of acquisition, let's suppose, and later on, I mean, the moment they announce the acquisition, and you would have seen in the market that whenever a buy-in transaction is announced, in form of merger, acquisition, deal, you would see a rally in the stock prices and volumes. And we have seen in past that there were companies which used it as a tool to machinize the price discovery of their scripts. They somehow interfered with it, using misinformation as a tool. So SEBI came down heavily on it. In fact, there was an entire period in which SEBI came down heavily on these kind of companies which were publishing without there being concrete basis for publishing so. So they said you were inducing, and they punished. Now, this being the experience of corporates in past, why would one dare to publish it, and how one decides and leave about the fear that would be there in the mind? What is the principle-based approach available to decide when to disclose or not? It's all subjective. Now, so far as the issue of UPSI in PIT is concerned, we have seen that there appears to be slight difference between Regulation 30 and PIT except on one count. These two are made for different purposes and should not be confused for each other. The problem occurs when the problem does not occur in law. Law is, I think, somewhat contained in their own boundaries. The problem occurs because one transaction, one factual scenario can make these laws collide with each other. That's where the problem arises. We have discussed the Biocon's case. In Biocon's case, a defense was taken on this acquisition that the acquisition got certain much later on. And it was said that it got concluded on the date of signing of the agreement, and then the disclosure was made. So the reasoning given by a whole-time member is that if we go by the view that only when the information becomes 100% credible, then only we will say that the UPSI has come into existence. It would leave the entire concept of UPSI infructuous. And I'm quoting this from the order. They have used the word that the concept of UPSI would become infructuous. Why they say so? It said so because it said that the people who are involved in the transaction, if the transaction is being discussed for long, there might be developments which the people who are privy to those discussions would know, and they would be in position to fathom or comprehend that this deal will go through or not. In the general presumption that can be drawn if a transaction is being discussed for quite some time is that the parties who are sitting together are one by one achieving the milestones, resolving their differences and finalizing step by step the issues. And later on, at some point in time, the entire transaction will culminate, which happens through execution of documents. But one should consider that the entire transaction is not discussed, analyzed, structured on the day when the contract is signed. The material part of transaction might be discussed on X date and the procedural parts on some other date. So that is why in Biocon's order, they said that nature of transaction, progress of discussion, outcome of various stages of negotiation, increasing probability of transaction going through. So again, there is a word probability. These are all the factors one should consider to decide whether the UPSI has come into existence or not. And this 2015 regulation is totally on the model of 3-tier self-governance. It is the company which has to govern, which has to come out and say, okay, UPSI has come. The power has given to them. Metaphorically, one can say that they have built the cats. So the power to determine and distinguish and come out and disclose is with the company, listed companies and the boards. It is not the regulator which will intervene and tell at each stage that no, here you should tell what the UPSI is. But equally true is that whether a company with its in absence of any strong principle, any core principle, as you find in Regulation 30, Sub-Regulation 4. I mean, I don't say that those are sufficient. Some more concrete principles should be drawn and laid down and given, provided to assist the corporates so that they can identify, because the objective is not to punish the insiders. The objective is to curb it down. If you catch an insider, if you investigate an instance where insider trading has happened, the damage has already been done. You're only doing postmortem and sending a deterrent message. The objective must be a little proactive. In advance, I think there are many measures that can be taken to lay down at least some guiding principles. If at least while passing orders, SEBI can lay down the guiding principles, why not in form of some regulatory circular or through FAQs, which SEBI has been very beautifully using in a lot of other cases and is widely appreciated for that. So that can be one of the approach to make it more proactive and to assist the corporates, because sometimes these kind of issues may happen due to difference of perception that I perceive and my counterparty with whom I am in transaction. We know that we are not going forward with the discussion because we are at loggerhead, or we have got some bone to pick in that particular transaction. But the regulator takes presumption, oh no, these two are big shots of their own respective areas. There is no matter, they would fail. Regulator may say that no, from the first day, they are very certain that they're going to do the transaction. Now, it is another question whether regulator can take such a presumption. Now, I feel such a presumption is not available. Only if the totality of factors tell the regulators that they can deduce from the facts or the communication correspondences exchanged between the parties. From there, they can deduce that what transaction at what stage the transaction was, as was done in Biocon. So in Biocon, another interesting element is that they took the emails in investigation and they analyzed it to see that how transaction was progressing. And that's how they came on to conclusion that yes, the transaction was progressing and UPSI had come in existence. Lastly, there is another matter, another legal development, and this is from SAT. It's an order of March 2021. In this matter, there was a transaction again, and in that transaction, plea was taken that the transaction was not at all UPSI because it was so insignificant. It was very insignificant. There was some acquisition, and the notices or the alleged persons took a defense that the transaction was so insignificant it could not have had any impact on, or much less material, any impact on the price of the scrap. The matter went to SAT, and here is what SAT pronounced. They said that the test is to see whether a prudent investor would be influenced by such an information or not. The test is not really how you perceive it. It might be small for you, but if it gives, it would, and again, I'm using the word inducement, but not in the negative sense. Inducement is otherwise a neutral word. Only if it is used with an intention to dupe someone, that's bad. Or the inducement is caused by something which is fishy or fabricated or known to be false, then the inducement is problematic. Otherwise, inducement in itself can be seen as a neutral word. So if the information induces a prudent investor in taking a decision which he otherwise would have not taken, then it becomes UPSI. So that is the test applied by courts. Now, I think that is it on the part of interplay between PIT regulations and LODR regulations. Just to summarize is one, there is no concept of that every material information would become UPSI, and it is clear in the regulation. Secondly, there are no guidelines, there are no concrete guidelines which would tell a company that yes, at this stage you should disclose. So I see there is a scope where SEBI can do a lot better to enhance this governance framework, because the real objective is to not send deterrent messages. Of course, deterring messages should be sent if at all there is a requirement, but the real objective is to curb down and make an ecosystem where the chances of these kind of instances happening is is lowered down. So that is it, sir. For now, we would cover it in question and answer.
Okay, Ravi, thank you very much. You have nicely covered the interplay. Now come to the Manoj. Manoj, now tell me your experience. You are doing transaction advisory, you are doing open offer, you are doing merger, you are doing various structuring proposal you are giving to the company. Now, what is your experience and how the law, which is evolving, and as a consultant, as a company advisor, because sometimes company is talking to you and asking you please take care of all compliances issues. So what is your experience and how you are facing problems, and what is the message you want to give to everybody according to today's law?
Thank you, sir. Good afternoon, everyone. So, as Ravi has very detail explained that interplay between the requirements under Regulation 30 of LODR, which requires disclosures, and when it becomes unpublished price sensitive information and causes restriction on trading or prohibition on trading under insider trading, prohibition of insider trading regulation. So, obviously, as Ravi has very well explained, these two are totally different concepts. However, there are certain conversions of the two. One is relating to integrity of the market, capital market, and that is the key crux for which SEBI has created these things. So there should not be disparity of information among the players who are dealing in the capital market. That is the key, and hence the requirement of Regulation 30 says there should be sufficient, timely, adequate, and accurate information relating to all material transactions or informations relating to a listed company, so that the investors can take a well-informed investment decisions. So that is the crux with respect to disclosure part. And when these price-sensitive informations are selectively available to one or two people, or some people, or selectively disclosed in the market to some persons, then it becomes a disparity in the market. Some people are dealing with having information and others are not having information. Some are having part of the information which makes them speculate on the market. So all these are creating a problem, and hence to maintain the market integrity, it is very important that these two regulations are properly maintained and good governance principles comes into play in any corporate life. So materiality is very important. What will be the impact on the market is very important, but there is no law which clearly says how, when it becomes material, when it should be disclosed. There is, yes, as Ravi was telling, we can have more better disclosure norms or some FAQ type thing like bright line test to determine when an information may be disclosed to the market. Merely starting of the discussion cannot be a time to disclose to the market, because it may be very premature to disclose and then later on withdraw that information or say that this is in this deal or this transaction could not happen. So that kind of information would also be a negative for the market. Whereas waiting till the last moment when the agreement is signed or transaction is actually concluded, then obviously it is in public. So there is no time remain where there can be a disparity of information among the people. So if, like Sir was talking about, what advice I can give. So if the team who are working on a transaction can keep the information totally watertight and cannot be leaked through any channel, then you can keep it till the last moment, and when the information is already published, then disclosure can go. Like in case of any merger transaction or takeover transaction, disclosure can go simultaneously of the public announcement of the merger, takeover offer, or merger when the board approves the merger. But if there is selective disclosure or some information is leaked in the market, then it is very important. It becomes very important that some people are having those information. Based on that, they are trading in the market or creating the volume and increasing the buying or selling in the market. Whereas other people, other believable investors are not having those information. So this kind of disparity need to be avoided to the 100%. That is the purpose. So key management person has to be very careful while discussing or discussing that any kind of transaction which can have a material impact. So all those, if they can keep it totally secret, if all the consultants or team who are involved in the transaction can keep it totally secret, then they can continue to hold those information till the last moment. Otherwise, it is better to give a proper, with all the disclosure that let's say a merger to happen between two companies. One is, both are listed companies. So both the companies should disclose that this decision has been started, in discussion has been started, and it may or may not get cumulated. These are the factors on which it will depend. So if that information goes into the market, and there was 100% seriousness from both the sides, and later on, if the transaction could not happen due to any reason, the same can also be disclosed that due to this reasons the transaction failed. And that is also would be considered to be a fair and accurate information to the market. If that happens, it's okay. But if it is just an initiation of information, nothing is concrete, then it is totally wrong to give the information to the market. So timing and maturity of the information is very, very critical, and each management need to see what need to be disclosed and when need to be disclosed. So there cannot be a similar single formula for everyone. Each transaction is different, each situation is different, and the management need to be very careful while making such disclosures. That is my advice.
Manoj, but if you are saying that whenever there is a transaction, both parties are serious and they should disclose subject to this, is it not open to manipulation? Because what I'm doing, I'll show everything and I have an intention not to do the transaction, but to create a market for this. Because when something good is going on in the market, price will go up. And after that, you are saying, no, because of this reason, I'm withdrawing this deal, and then market will go down. So where the investor will go? So point is right, you are saying, but it is also not correct also in that sense that in the process, small investor, because they don't have that types of caliber and that types of sources to verify that this transaction will go or not. So credible information and correct information should be the crux.
Right.
For that, if you are giving information, it's open for manipulation.
Sir, but we have to understand that the disclosure requirement under Regulation 30 is very much clear. It has to be timely, uniform, and on the basis of ongoing basis, not at the end of the information. So ongoing basis information need to be given. If there is seriousness, there is confirmation that let's say the valuation is already established, all other material aspect is finalized. Only teething problems are there. Procedural aspects are getting negotiated between lawyers. Then this information, if it is leaked to the market selectively, or it is leaked to certain persons, then it is wrong. So if we can keep it totally watertight, then it's fine. We can continue till the last date. But otherwise, it is better to disclose. If, like in many of the cases, we have seen that, let's say, Economic Times or some other newspaper says that we know that this transaction is going on. This negotiation is going on. So that information is coming from unofficial channel, but officially nothing is coming out, which is wrong, which can create a problem. So that is the important aspect. We have to time it properly. We have to see whether this information should go or not to go. If everything is clear, then obviously a deal can even break at a later date. Let's say definitive agreement is signed and it is subject to certain approval or certain condition precedents, and the condition precedent does not materialize even after the long stop date, then the deal falls apart. So in such case also the disclosure need to be given in any way, and we cannot say that we will keep it open, we will not disclose till the approval is coming. It is not possible. So disclosure need to be given at that time when it is concrete and material, and there is a possibility to give proper information.
Do you have any view on what Manoj is saying?
Yes, he's absolutely right. The concept of UPSI does not provide a mitigating factor that your transaction would not fail. That's not the security provided by the concept of UPSI or materiality. The concept of UPSI is that if you know that you are going to do something, and the moment there is an asymmetry of information, you should disclose. Either you should keep it preserved under watertight format. I mean, I have my own doubts whether a company can take a decision under its discretion that we have a UPSI, but we are not going to disclose it.
Okay.
But the point is, the moment asymmetry of information kicks in, the UPSI kicks in.
Yes. So,
Okay.
sir, in case of UPSI, it is very clear. Those persons who are having UPSI should not trade or deal in the securities of the company. But there can be people who are having partial information, leaked information, partial leaked information, and based on that, they are started speculating in the market. Which kind of things are very bad for the capital market, integrity of the capital market, and hence regulator is very much concerned about that.
It's very clear. If a transaction is starting, it is finalized or it's the initial stage, all those people who are in touch with this transaction, they are barred from
Dealing
trading,
in the market.
whatever it is, whether
Yes.
it's information, material, non-material, it's not a question. Okay. Now the question is that which you are saying, it will not open Pandora box that whenever transaction is taking place, you inform and then tell them.
No, that is not the situation. Each initial stage discussion or maybe term sheet signing would be a trigger point to disclose. No, that is not the correct position. It is the position that when the transaction is almost crystallized, all finer points, major points are already crystallized, then disclosure need to be made, or it should be kept totally watertight and kept till the board meeting and approval happens or signing happens. Yeah.
Okay. Rita, you have, because you are going open offer, you have done more than 35 open offers. What is your call on this? What is your experience? How you have faced this?
Thank you, sir. Good evening, everyone. So just to summarize what Manoj sir and Ravi were discussing, I feel when somebody may be motivated to trade with having the UPSI, that is the correct stage of disclosing it. Now, we were discussing when the term sheet is signed or maybe the transaction is initiated. I would say at that stage, even the person who has that UPSI may not trade in the security, considering the probability of completion of that transaction or not completion of that transaction. So once the things are materialized and the company or the compliance officer is of the view, or the board is of the view, that now these people who has the UPSI may trade in the securities of the company, then that stage, maybe with 90% of the probability of happening of that deal, or maybe with 50% of the probability of happening of that deal, that should be the stage when the disclosure should be given to the market and a parity should be maintained. So in my opinion, this should follow, in simple words, this should follow for all the transactions. With respect to takeover open offers, I would say SEBI has very clearly and critically drafted the takeover regulations, and it states that on signing of any understanding, any type of memorandum understanding with which is triggering a transaction in a listed company, then you need to give open offer. So the things happen simultaneous. So in those transactions, there is practically there may be certain discussions, informal discussions, or non-binding discussions, which would have been done in last 1 week or 15 days, but there is nothing conclusive or conducive which could trigger the transaction. So that conduciveness and that triggering happens on the same day, and then you have to give open offer also on the same day. So the period of UPSI practically may not happen in those transactions. This is my opinion. So other people may add. So
okay,
yeah.
I think everybody has given their point of view. Let's have question answer, and then in the question answer you can give your point of view. So I'm taking first question. Sobit Agrawal, I have a question. Electronically database under PIT. Can a company maintain database electronically through there is no trade occurring on the stock exchange platform, Moini?
Sir, SDD is not with respect to the trading data. SDD talks about the collection of information with respect to the UPSI.
So compulsory whether it's a trading or not trading.
Not so it's trading not happening, but still you being a listed company, you have the information which is of UPSI nature. You have to maintain your SDD.
Okay. Anjali, can a advertisement agency consider to insider person?
Yes, it is.
Yes.
All intermediaries fall within the ambit
No, because you are giving information to him for result and other
for the
things.
purpose of results, for the purpose of various publications. So it is an insider.
Okay. Does trading plan is practically utilized by any designated person in India? What is the legal in India and outside India, Mohini?
Very few, less in it can be counted in trading plan. So because the trading plan important, why it is not being in use? Because it's a complete necessary that whatever the transactions you have mentioned in your trading plan, you have to do. You can't do away with it without it. So this is the reason why the trading plan generally not being used by the KMPs. But if the suitability amendments are being considered in this particular trading plan, I think it is the very best way for the KMPs to avoid in any kind of indulgence in insider trading.
Okay. And sometimes what is happening, you have taken a trading plan for some particular occasion and that occasion is not required, or even then you have to execute the trading plan.
So yes, so that's the reason it's need to be either when that occasion is not happening in that case. So generally the KMPs are not giving their trading plans.
Okay, I'm asking this question, and anybody who has additional view, please raise your hand so I can ask them also. Okay, is provision of Cbpit regulation applicable on debt listed private company?
Yes, debt is a security. So PIT is applicable on the debt securities which are tradable on the exchange.
When borrowing from promoter, Anjali, borrowing from promoter company will be considered in UPSI?
Borrowing from, yes, borrowing will be considered UPSI.
Why?
Sir, number one, it's a related party transaction. Number two, on what terms I am borrowing. It is known only to the company or to the promoter. So it is UPSI.
Moini, you have a different view. Ravi, you have any view?
It's subjective, but she's right. If the scale of borrowing is, is the factor which would make it stand out, then yes, borrowing could be a UPSI. Not in every case, but borrowing could be a UPSI.
Moini, you have any view?
No.
I think Ravi has correctly said, if the size is important, if it is very minuscule amount, or if it is a small size transaction, it may not be a UPSI. It might not have any impact on the business price of the company. But in many of the cases, if it is getting used to replace some debt or to establish some new plant or something, then it is very material and it needs to be disclosed.
Okay. Generally, any KMP is required to give 2 to 3 months notice to resignation. However, we see lots of announcement of stock exchange that of the last day of the relieving, then how it is viewed. Anjali.
So the legal provision is that the information with regard to change in KMPs has to be given. So only when the person is leaving, the actual outcome is given to the stock exchanges. But yes, you are right. That again is a UPSI. When any of the KMPs is resigning, it again is a UPSI. It is a material information. Ideally should be disclosed beforehand.
Ravi or Manoj, my question comes again here. It is a transaction which has started long back. The resignation process, if somebody has resigned, he must be communicated. There is an appointment letter, there is a terms and condition, and in no KMP terms and condition can be less than 2 months. Okay, less than 1 month also, I can just say on a liberal ground. So if he has started, he is going, the last day you are giving information, is this not a violation of the?
Yes, it is. It has to be on the date of resignation itself. There is no question of keeping it till last day. It is wrong. If it is a KMP which have any material impact on the business or market price of the company, then disclosure is very, very important.
Just say CFO or company secretary resigning. They are both-
Sometimes company secretary may not be material. It may be sometimes if CFO may also not be material. Very small person, fresher, 2 years experience, then it may not be material. But in all other cases, if he is a KMP, he can have impact on the business and the profile of performance of the company. Then it has to be disclosed on the date of resignation. And notice period need to be, because he will start discussing with other companies some other job opportunity, or company will also start hiring someone else. So all those discussion will selectively give information to some people, but not to all, which is wrong. The fair and equal disclosure to all is very important.
So you mean to say if
The date of resignation should be disclosed immediately, not to wait for the notice period.
Okay. For example, company launched 2 plans in the month of today. Can board give disclosure of regulation 30? What is, I think this question. So with this,
Your voice is not coming clear, sir.
for example, insurance company launched 2 plans in the month of today, this month. Can board give disclosure in regulation 30? I think this question is not clear. So please write again that question clearly. Okay, now as regard UPSI period, will it be okay if we disclose the same through press release? In my opinion, it should first be disclosed to the stock exchange even before it placed on company website and also given press release. So the clear question is, he's saying I have to give first to the stock exchange, then press release, or I can give press release, then stock exchange. So what is the correct picture?
It has to be simultaneous. How much gap you can make, that is, it should be minimum. The gap should be very, very minuscule. It has to come, should happen simultaneously.
Okay. Mohini, can you please elaborate how the proceedings of AGM and EGM comes under UPSI?
Because at the time when the AGM is being held, so there are very few stakeholders are present there. So not everyone is aware of about the outcome of the AGM. So till the time outcome of the AGM is being released, for that particular time period, it is in UPSI, because the people who are present there are very less in number.
Okay. Okay. Any view, other view?
Again, the test would be the likelihood of such outcome materially impacting the price of a script. That is the test. The test of likelihood and investor decision.
Okay. Okay. Chairman intimate the secretary of the company the date of the board meeting to consider the unaudited financial result for the quarter ended 30th June 2022. And also the confirmation about the date was sought from the other members of the board. The date is from whether the UPSI concept starts and the company has to intimate the stock exchange the date of the board meeting, or UPSI starts immediately.
Sir, in the financial results, the UPSI starts from the very last day of the quarter. So irrespective of when you are fixing your board meeting. So your consolidation of the results starts. So from that very date, your UPSI period will start.
Okay. Any different view?
Sir, by default, they have said that trading window need to be closed from the end of each quarter till the board meeting and 48 hours after that. So they have taken a very cautious, very conservative view that from the very first day there can be information which can be material. So that is already there. So now there is no question of UPSI in such case.
Okay.
Obviously, sir, but yes, obviously there will be UPSI if the managing director or CFO start canvassing someone, informing about the result, probable result which will come, then it is wrong and it will be treated as insider trading, which is prohibited.
Okay. If there is a delay in giving intimation to stock exchange regarding the regular quarterly trading window closure, will it be considered a non-compliance?
So there is no requirement in the PIT per se that you have to disclose it to the stock exchange that our trading window is closed.
Yes.
So
But Mohini, wasn't there a guidance note from SEBI which talked about informing the exchanges about
If we are informing to the exchange that my trading window is closed for some UPSI, so it becomes why it becomes an UPSI then? It becomes that
Right.
there's something going on in the company. So trading window concept is with respect to that the trading window is to be informed to the person who are privy to that information that they can't trade.
Right.
Trading window closer need not to be informed to everyone that yes, something is going on in the company and the trading window is closed for that.
Yes.
So trading window is personal to that person. That
Yes,
you can't.
that's very correct. There is no requirement to disclose to the market that trading window is closed for any reason, including the quarterly result, because it is by default. The law says that trading restriction period starts from the end of the quarter. It is not talking about the trading window closure and disclosure of the same. Though companies are doing that, but it has nothing to do with the regulation.
Okay. Would change in KMP trigger need to have a trading window? For example, retirement of a company secretary and appointment of a new one in his place. Does this require a closure of trading window for this purpose? The reason this question is raised is change in KMP is classified as UPSI.
So I think the person who the retirement is definitely because by virtue of the law, the person is retiring, but you are appointing someone. So that will be a critical. For example, CS is there, but CFO or any director. So to whom you are appointing, if it can be a person who is leading the market already. So the person who are involved in this appointment process, for them, definitely this is a UPSI, and for them, the trading window is closed. For that particular, there were that bundle of people who are involved in that transaction, not for everyone, the entire designated person.
Everyone may not be privy to even the rate of retirement of a person in a company.
Right.
So yes, for those people who knows that, let's say the terms of the KMP is coming to an end, then he should not trade in this.
Ravi,
Like any HR team is there who are looking for the consultancy organization who you have appointed for appointing that person. So these people are.
Follow this particular thing. He's retiring, so I am not informing. A new person is joining. So what is the violation I have done? Because Manoj is saying this is a information which you have to give. But suppose
so see, the question is retiring. It's not the person leaving the job. Retiring means, in a general parlance, that the person has been with the organization.
I don't know when you are turning 60. I don't know. And I think.
No, I'm not talking about that, sir. I'm saying that means you have been with the organization for quite a long time. And that is why you're retiring from that organization. In a general parlance, there can be situations wherein you join only 2 years back. But if you have been with the organization for a very long time, you are a part of the entire system. And you are aware of many of the ins and outs of the organization.
Less so many questions I have to finish. Okay. Where there's another interesting question has come. The fraud defaults disclosure should be made at the time it has alleged to have been committed or it's established that the entity official have committed frauds default. Sometimes they are challenged and the outcome is reversed too. So when the disclosure, because somebody is saying you have done fraud, but it is not actually fraud. Somebody has only blamed. So Ravi, what is your view?
I think the answer is in Schedule 3, Part B, and item number 8, which says regulatory action. When there is an action, you have to disclose litigation or action. But there is an interesting angle. So far as LODR Regulation 30 is concerned, this is the view. But come to UPSI and the view changes. Issuance of a show cause notice has been held by SEBI to be a UPSI back in 2018 in the order of 63 Moons Technology, where a regulatory action notice was issued to National Spot Exchange Limited, subsidiary of FTIL, and there were dealings, and they said that no, you have dealt on basis of UPSI. So this information might not be material in LODR, and it's a live example of it, but it is a UPSI.
Okay. XY Limited is listed company and board of directors to participate in the event occurred outside India with a view to support top line of the firm that event company received monies which is marginal earning. Can such disclosure is treated as material disclosure? I think you have given your answer, Sovit. So this is not a material. Materiality will be seen from the company's angle, where the money is coming. Am I right, Moini?
Right.
Okay. So please throw light of applicability of debt listed company. So
I think we have already discussed it.
debt listed company is applicable. Can company secretaries bind to give prior intimation for amalgamation or not? Or it is a suffice that company gives outcome of meeting of the stock exchange in the matter of amalgamation. So
It is only the outcome is given. When decision happens in the company, listed company takes a decision to amalgamate or to amalgamate someone into it, then only disclosure is made. But yes, as we have discussed earlier also, if the information is partially already leaked in the market or somehow it comes in the market, then and everything is almost crystallized, then it is better to disclose. So that timing question will remain always, but as per the law, only outcome is to be given.
Okay, friends, I have 22 more questions. Okay, so I will be very so rapid round is starting. So just very short and crisp. Whether a policy determining material information fixing a value of ceiling, say 500 crore relating to fraud or default committed by director of KMP is a fair determination as per SEBI regulation. Will such determination stand the test of SEBI parameters? Which I was asking that question. So if you are fixing the 500 crore rupees value, is it correct? I don't think this is correct, because 500 crore rupees is a very high amount in all aspects.
Sir, this is not the case, because as Anjali ma'am was showing, a few of the companies has kept $200 million as a limit threshold. So 200 million is around much more than this, around 1600 crore. So that ceiling is already available for some companies. So it all depends upon the size of the operation. If it is 18 lakh crore company, then obviously 500 crore would be very minuscule amount. So everything depends upon the size of the operation.
But the nature of offense in this case,
and the nature of offense is also very critical. Yes, it is
if
not
it is
about
fraud,
the
even if it is for a very insignificant amount, it's a fraud. It reflects badly on the company.
Yes. So if a managing director is involved in a fraud of 10 lakh rupees, then still it is a very critical.
Still it is material event.
A question for you: Lux Industry SEBI passed an interim order pertaining to UPSI, where order SEBI debarred managing director of the company about they capture all information from social media, LinkedIn, and others. Can SEBI has a power to capture such information? Further, any user has forgot to update his or his information, will such person is found guilty? Answer is yes. Ravi, I'm not asking this question.
Yes.
Answer is SEBI has a power to do this.
Water has already flown under the bridge. He must read the order.
Yeah. And second is, you are saying that you have forget to update. So if you have forget the update, it means you have some link, whatever it is mentioned, there must be some particular connection, and even if you have forget, that SEBI can catch hold of this.
That may be proved at the time of adjudication. If he is not guilty, if he has no connection at all, then he can prove it.
Manoj, SEBI has recently kept in insider trading, they have catch hold a person. They have no business relation, nothing else. But when SEBI did their social media, they came to know that they were close. They were
yes.
Friends, they have studied together.
Right.
From there, they have linked everything, and they have proved them.
Obviously, it can be a way.
Yeah. Topics discussion during company management meeting with research analyst or fund manager should be transcribed and uploaded on the IR page of the company website, compulsory as per the disclosure regulation, listing regulation, or the optional for the management. Anjali. Anybody, Anjali, Monica, anybody can.
Yes, it is. Transcripts of investors discussion, investors meet discussion need to be on the website of the company.
Has to be there.
In case of new unit, disclosure to be made when land is purchased or CLU is taken, or when commercial production is going to start, or when management will put up to the board for approval of unit. Please clarify.
Sir, yeah, sorry.
Yeah. So in this scenario, this is a real complicated situation and a practical situation. Our advice to companies remains that you give a disclosure as do not mention any of the facts of the transaction, but give a disclosure that further details will be updated as and when they happen.
So as per Manoj, what Manoj has said is right.
Yes, sir. Here it is very clear. If the management decides to put a new unit, that is a critical decision, and they should disclose after the board approval. Right after that, there will be different stages. So updates may be given on critical milestones. So it is not that the one disclosure is sufficient. If you are saying we will put a new unit which will increase your turnover to double, right? Let's say. So that decision of the board is critical, and that disclosure need to be made. And if information is concrete that it will be funded through capital or through loan, and what will be the bifurcation, all those things should be disclosed properly. Adequate disclosure need to be given, and then updations may be given at a later date.
So Manoj,
Yeah.
if you are purchasing land, it means board must have discussed that we want to install a unit. So
Yes.
as soon as board has decided, you must communicate and tell them that now we are purchasing land, and then at the finality of the board meeting, when you have completed everything, then you again disclose.
Yes.
Sir, I think SEBI is also very clear in many of the cases. They say that the UPSI persists till the completion of that particular event. So only the purchase of land is not the end of the UPSI. So whether what kind of plant, what they are adding to the unit's production and all. So till the time it is completed, it is in UPSI. Stage-wise declaration make easy for the company to that the information is in public. And
UPSI start when the board is deciding that we are increasing capacity, and in the process they are purchasing land, they are purchasing machines, they are doing this. So till the time all UPSI is going on. So in the process, suppose the machine is delayed, the machine is defaulted, so your plan is delayed, so that you have to inform all these things. So UPSI started from first day, and whatever material fact which is affecting positively and negatively, you have to inform. Okay. Acha. Okay. Now it has explained that proceeding of AGM, EGM is UPSI. How proceeding of AGM, EGM can be UPSI? I believe it is a material and not UPSI. Kindly elaborate. Poini.
already explained.
Already explained, I think.
No, somebody is counter there.
Sir, it is not about the UPSI, unpublished price sensitive information. It is not that. It is only what kind of disclosure is there. Yes, there may be a set of people who are there and who knows that the result has been approved. But there may be hundreds of thousands of other people who are not knowing the result has been approved. So it is better to disclose that till the time there is asymmetry of information, and that is unpublished price sensitive information.
Maybe a very interesting question. One director hired a Uber cab after the meeting and passed on such information of the meeting that company is giving bonus to the driver, and driver purchased it. So driver.
It's a classic case of insider trading. Tipping and then getting the insider trading done, covered by both classical theory and misappropriation theory. And if that cab driver further goes and tells the union leader that this has been done, then it's a mass level insider.
Okay, so it means the driver is guilty.
Yes.
And if he is trading, yes.
Only if he acts on it.
If he is trading or if he is passing on, both case he is guilty.
What about the director who has passed?
Director is certainly guilty. The moment he uttered those words to driver, he is guilty because he failed in his fiduciary duty to keep that information confidential. He selectively disclosed it. Okay. Therefore, further the menace of insider trading.
If there is a delay in giving intimation to the stock exchange regarding the regular quarterly trading window closure, will it be considered non-compliance, Moini?
Already told that it is not required.
Not required.
Not required to disclose.
Will buying an immovable property is a UPSI?
Unless there is a purpose. Everything depends upon the purpose. Why this investment is being done. Whether it is just a parking of the surplus fund, or it is for some expansion of business, or the company is into real estate and hence it is a business investment. So what kind of business the company is, that will decide.
A clear answer.
There is no clear answer of any such transaction. So you have to say you have to tell what is the purpose of purchase. What was the decision? What was the thought behind purchasing that immovable property? That is the critical aspect. Okay. If a 1,000 crore company is buying a small flat for guest house purpose, it may not be material at all. So,
okay.
So we have to see.
Sir, but I have a different view. If the funds of company are used to purchase a immovable property, even if it is not contributing in the business, then it may be material for shareholders.
Maybe that's what I'm saying. If it is, let's say, a small flat by a 1,000 crore company, investing 1 lakh rupees, 10 lakh rupees or 50 lakh rupees, it may not be material. But if it is a substantial investment, it is material. So everything depends upon the size of the company, business operation, purpose, all those things are very critical.
Okay, can promoter of a company trade in securities of the company post seeking shareholders approval on its and QIP is pending, no concrete date of same is finalized?
So recently, I think SEBI has given the informal guidance in Deepak Nitrate on this. That QIP, because the number of the after the shareholders approval, because it's the amount which you have taken the approval, it is not completely concluded. The QIP is not completely concluded. So till the time it is concluded, within that period of 1 year, which is allowed by the law, it is still an UPSI. But there they have mentioned that it is an UPSI, but promoter is trading or not, that their decision is there. And if they are trading, they have to prove that they are not aware of the information or so. So trading window closure is important for those persons who are involved in that. So it's not that for everyone QIP is not concluded, for everyone the window is closed.
Listed company may require to file a stock statement and other financial data of 15th each month of bank to bank, and it is before declaration of UFR. Is it UPSI? And if it is, then precaution disclosure required.
It is in UPSI because financials they are treating it as in UPSI. So there is a very clear-cut policies in the company that the sharing of the information for the legitimate purpose is to be framed by the company. So it is a legitimate purpose because they have borrowed, and if they are sharing, then the person need to be informed that this is a UPSI and they can't trade. So this is the process which has been defined in the law. The company has to follow when they are sharing the information.
Right.
Will trading window be required to be closed before disclosing UPSI to stock exchange? Every time trading window is closed to stock exchange, be intimated like in quarterly result.
So I think many a times we have mentioned that no trading window need to be disclosed to the stock exchange. It is to be disclosed to the persons for whom it has been closed.
Okay, so for all participants, trading window disclosure is not required to the stock exchange. Trading window disclosure required for your people, those who are insider, those who possess information, or those who are supposed to possess information. Okay, I am not satisfied with the answer given by Manoj. Intimation to the stock exchange has to be given prior to the press release. Press release even can be given after 2 days after giving intimation to the stock exchange. No, Manoj's answer is, he's saying simultaneously. It is not that you have to give
So, sir, that's what I'm saying. So information to stock exchange is for the mass investor, and press release may or may not be for the mass investor. There is no law which requires press release to be given. So the requirement is to give the disclosure on the stock exchange website. It has to happen simultaneously if you want to disclose to anyone else. So if you are giving on a stock exchange and not giving the press release, there is no offense at all.
So I think Rajesh, your question is clear that press giving information to stock exchange is compulsory. Press is releasing optional, but you cannot give press release before giving to the stock exchange. That is the main thing, because press release may reach to somebody, may not reach to somebody. Okay, XYZ Limited is listed company and one of the promoter group is admitted in insolvency and such company is not listed. Can such information is considered as material or not, Manoj?
Yes, it can be.
Okay, since there is a regulation stating that the trading window shall remain closed beginning first day after the quarter is over till dissemination of the financial results. Moini.
So it is defined in the law that trading window is closed from the last day of the quarter till the 48 hours of conclusion of the board meeting.
Okay. Should be
that is called trading restriction period, not the trading window closure.
It's a restriction period.
Restriction period.
Should we close the trading window for the entire period of right issue, or can it be opened once record date is announced? Anjali.
Once the information is public, we can open the trading window. But here and again, because the observation letter, just like the case of Deepak Nitrite, the observation letter which is issued by SEBI is valid for a period of 12 months. And there may be a change in the terms of the issue of opening. So in that scenario, the open of the the trading window will remain to be closed. Otherwise, it can be opened once the things are in public.
Okay. An independent woman director resigned and new person has been identified, but as per the nature of the business of the company, various regulatory authorities approval is required, which sometimes takes 9 to 12 months. When should this be informed? When the candidate is finalized, the application has been made for approval for various regulatory authorities, or only when the appointment is made after the approval are obtained. In my opinion, when you are appointing, you just write, we are appointing this person subject to the various approval, and when the approval comes, you just inform again. That is a simple answer.
Yeah.
Okay. Second term of independent director ceiling limit. Second terms of independent director ceiling limit. I don't think Mr. Jha's question is not clear. Please send it to us again. Can we give a blanket letter to exchange regarding quarterly closure of window till dissemination of financial results instead of every quarter? I think, Moini?
Sir, because the companies are following the practice of making the information to the exchange that our trading window is closed. Yes, till the time whether your board meeting is not fixed on the very last date of the quarter when you are closing. So you can give it will open after 48 hours of the board meeting.
Okay. Secondly, is the same question is Rajat is asking again about the purchasing the building, purchasing a land. And second, if the new unit is not adding material capacity, say 10%, then whether it still is a UPSI. Manoj?
Sir, as we have discussed, it depends upon the policy and probable impact on the market. So if the policy is that less than 10%, you will not disclose, you may not disclose. If the investment size is much more, even if the outcome is less than 10%, it may become material and disclosure may be required. So that all depends upon what kind of investment you are making. Whether, let's say we are 10 crore company and we are making 5 crore investment, but the result will be 5% increase in the turnover. Still, it is 50% investment you are making, so it becomes material. So everything depends on the case to case basis.
Okay. Is the company secretary continue after the completion of age of 60 years?
That totally depends upon the management of the company. If they want, they can continue the person. And in many of the cases, it happens.
Okay, ND is executed and the trading window is closed for some people relating to UPSI. Should all detail be entered into SDD? And Moini?
Yes, SDD. Yes, compulsory.
Okay. So I think all the questions which we have received, we have given answer. 1 and 2 questions which are there, which we have written. Who has power to drive? What is material information for the company, Anjali?
The KMPs, company has to authorize its KMPs to determine whether any information is material or not.
Okay, Ravi, with respect to show cause notice received from regulatory, which may entail have penalty in future, and what is the disclosure is required?
Disclosure is required as per LODR when the regulatory action is taken, but it might also be UPSI, so care needs to be taken. Please refer to the 63 Moons Technology Order of January 31st, 2018.
Okay, does an information ceases to be UPSI upon its disclosure as the material event, Moini?
Sir, if it is concluded at that point of time, yes. Otherwise, it will continue till it is concluded or discarded.
Okay. Luchka, if the promoter enter into settlement with SEBI, is a disclosure needed to be made for settlement?
Again, depends upon whether it is material. If it is affecting, I think yes. I think yes. In my opinion, it should.
Don't give confusing answer. Give the.
It's yes.
Because people
It is a part B item. It is a part
action.
B
So
item of Schedule 3. Yeah.
Regulatory action.
Anjali, an overseas subsidy is getting dissolved. Is a disclosure needed to be made for the same?
So depending upon the materiality policy of the company, it should be disclosed.
What is the importance of Regulation 30 of SEBI Regulation 2015?
I didn't get the question.
Regulation 30.
Okay. Importance of the Regulation 30. The idea is that the public should be informed well in time to be able to take a conscious investment decision.
Okay. Ravi, can any information which is non-material even be UPSI?
Yes, very well.
Example.
For example, the regulatory action letter. It is not material, but it's a UPSI.
Okay. What should be the principle which can be used to define any information as UPSI, Ravi?
There are 3 principles. One is that it must relate directly or indirectly to the scrip of company. Second, it should not be generally available. And the third one, and the very critical one, is that upon becoming generally available, it should be able to materially, or there must be a likelihood of this information materially impacting the scrip price.
Okay.
These are the three essential ingredients. If one is missing, there is no UPSI.
Okay. Vanjali, whether any information which is UPSI but not material information as per the materiality policy shall it still be disclosed under regulation 30 of LODR?
If it's not material, it's not needed to be disclosed, because there is a possibility that all UPI, all unpublished information may not be material.
Okay. Mohini, does policy of materiality and list of UPSI need to be disseminated to the public at large?
So materiality policy need to be, but UPSI, list of UPSI need not to be disseminated to public at large.
Okay. At times, the company undertake diligence of business for purpose of acquisition, including discussion on terms and condition of sale. How such case shall be dealt with the purpose of disclosure and closure of window? Ruchika and Manoj, anybody?
Sir, it is, are they talking about, I don't know whether they are talking about disclosure to the persons who are doing the diligence. If that is the case, yes, they would be considered to be those persons.
Manoj,
who
your
are involved
voice
in
is, Ruchika, you just give answer. Manoj, your voice is not.
Sir, if we are talking about disclosure to public, then I think at the stage of due diligence, in my opinion, it should not be, because at that time, the possibility of happening such transaction is not clear. So at the time of conclusion or maybe conduciveness of any deal or transaction, then disclosure should be given. Manoj sir, you may add.
Yes, I was just telling that if it is they are talking about disclosure UPSI for the persons who are involved in the transaction, it is deemed to be UPSI and they should not deal in that scrip of the company. So that is for the limited number of persons who are involved in the transaction. For the public at large, it is disclosure should happen only when it is crystallized. So crystallization may not be the final signing; it may be before that also. So that timing is very important. I think.
Can I add something to it?
Yeah.
Can I add something to it, sir? So if we refer to this Biocon order, they have used two very important terms. Another one is already used by Ruchika. Number one, is the first term is very important, exploratory. So if the stage is only exploratory, which the due diligence stage is, you are exploring whether to go ahead with the transaction or not. There is no existence of UPSI. Only when you decide that you are going ahead and there is some certainty, the degree of certainty is not important. But if there is certainty, the UPSI comes in and the three principles still needs to be applied, just to clarify.
Okay. Mohini, lots of companies keep materiality as 10% of turnover. In such cases, company with turnover of 10,000 crore avoids disclosure of any transaction involving amount less than 1,000 crore, while even 999 crore, 999 crore is substantial amount. Is such criteria good for corporate governance perspective?
So it again depends upon the management, the KMPs who are deciding the materiality policy. So they have to decide the material, what is material for them. So it cannot be seen from the perspective of the public, that public will deem it to be a material. So it is from the KMP who is deciding that it is material or not.
And but on their decision should be logical.
Logical. Yeah, it should be on logical.
Yeah, so there cannot be only objective criteria for decision making.
Yeah.
It has to be objective as well as subjectivity. Subjective. So subjective part needs to be seen.
MD of the company met with serious heart attack and remains in a critical position. Does need the information?
Should be informed.
Okay. There will be 2-3 legal question. If any UPSI is being displayed by news channel or regional state, does it will be termed as public information or will remain UPSI?
No, if I go by the words used, regional channels, no. Wide dissemination is the concept, and it was also discussed in the high-level committee report of Justice N.K. Sodhi. In fact, another consequence of doing or following this kind of a practice is that one may be additionally charged with the violations of FUTP, because you are selectively disseminating it while still keeping it obscure from community at large.
Okay. Ravi, in case of where penalties imposed by any regulator, what is more important, the penal amount or nature of offense or determining the materiality?
I think it's a question which answers itself. There is a concept of proportionality which says that you must punish a person in proportion to the offense. So the penalty and offense would always be in proportion. That's the first assumption. Secondly, if you start with the nature, you would always be able to determine that it should be disclosed. The nature is the first thing you should consider.
Okay, how compliance officer should deal with case where he himself is not aware of any UPSI? Can he take the ignorance plea before regulator?
Well, UPSI, because it's a factual thing, apart from the 5 UPSIs, those are listed, which are ordinarily UPSIs. Apart from this, if there is an UPSI, which is a factual development, a plea of ignorance can be taken because it's not a legal concept, it's a factual concept. Some elements of laws are there, though.
Okay,
If the company secretary is not involved in the transaction discussion and he cannot be privy to it and he cannot be held guilty, but he has to prove practically.
But the situation would change if those are one of the 5
the
UPSI factor.
Yes.
last 2 questions. At what time disclosure given by company during market hours or after market hours? Moini.
I think it's generally the practice. If we found that many of the companies announce their financial results after the market hours, so that particular day it will not going to affect. The next day it will affect.
Have a meeting at 12 o'clock. Then immediate after my board meeting, I have to give result. That's it. It's not a question of if company give a notice to levying penalty for delayed submission of information on NSE, then it is required to be disseminated on exchange. Anjali.
Needed to be given, sir. Material.
Pardon?
Material needed to be given.
The regulatory action, sir.
For levying penalty for delayed submission of information on NSE, then it is required to be disseminated on exchange. If yes, within what time?
As soon as possible. There is no time defined for it, but it's a para B item.
Yes.
So it has to be disclosed as early as possible.
Okay, so thank you, friend. We received around 43 questions and then 53 and then I think 60 questions we have received. Okay. Last question I have then received: court announcing the judgment in the open court. Is it a UPSI or not? Anjali or Moini, anybody?
Court announcing. Okay.
Court announcing the judgment in the open court, is it a UPSI? Not. Answer is yes, because if the court has given a verdict that the license is granted or license is cancelled, it is a UPSI. Okay.
It is a material disclosure information. It has to
I
be
think
disclosed.
these court proceedings are public proceedings. So the information has been done. I mean, that's a whole together new nuance. I think we should do a webinar on this particular aspect.
If it is not disclosed to the capital market, then obviously those persons who are in knowledge should not trade in that security.
Yes.
Courtroom. I know the information. Nobody knows this, and I trade this. So and I'm the company person. Okay.
Yeah.
But Manoj, if you are sitting and you are not the company person and you own of this,
Right.
And you have traded.
So then I may not be held guilty because I am having a public and court hearings are public. If it is publicly disclosed judgment, then I cannot be held guilty.
Okay, friends.
This is important for the company to disclose it to the market immediately.
We have received so many questions, so we have exceeded time. Now it's a time to close. My question is, Radhika, your answer we have given you. Okay, so we are closing this session, and I thank everybody. I thank all the participants. As a ritual, we are doing just 10 seconds. What is your suggestions to regulator and the people? So this law should be very clear. I will start with Manoj.
I think for regulators, they may bring some bright line test type of concept where they will give some example and say this kind of things, this will be the right time to disclose. It may help or make it symmetry in the market. But otherwise, law is very much clear. And if the board or management is following good governance principles, they can understand what is the right time to disclose.
Okay.
And that is a good thing to happen.
So yes, sir, the regulator should give an example. I agree with Manoj that when it is to be disclosed, it is the better way, because otherwise it will remain an subjective matter that when to disclose and what is basically the UPSI period, because UPSI period is over when it gets disseminated. So if the lawmaker makes it clear, then it will be good.
We must clarify between the interplay on this regulation 30 and PIT regulations. That's number one. Secondly, principle-based approach should be applied. And third, proactive approach must be considered rather than deterrent. This is because in deterrent approach, damage is already done. You can't repair the losses of small and medium shareholders. Confidence is shaken. So proactive over deterrent is the key.
Okay, Anjali.
As I said in my presentation as well, the subjectivity involved in framing the materiality policy, I think regulators should really look into it so that the discretionary things which the companies try to cover, that will be taken care of.
Last, Ruchika.
Sir, for the interest of shareholders, I think it is very important for a regulator to come out with a specific guideline and principle at what stage, what need to be disclosed, when you should disclose it, how much you have to disclose it. So I think a detailed guideline should come over it, as Manoj sir and Ravi has already mentioned, maybe in view, like not like a regulation, but as a bright line test or general guidelines which should be followed in all of the cases.
So thank you very much, all my learned speakers. You have given answer of all questions, and interestingly, we have received 65 questions, and which we have given answer. And
sir, but before you close, sorry to interrupt. I think there is one participant who is asking Ravi to repeat the 3 principles before judging anything should be UPSI or not. So Ravi, if you can just repeat for everyone who are present.
One is that it should relate to the scrip of the listed company. I mean, the securities of the listed company, the relation could be direct as well as indirect. That is important to note. Second is the information should not be generally available. And third is that information which was not generally available, upon becoming generally available, would materially affect the price of the scrip. And all these 3 ingredients and elements should be present. If anyone is missing, there is no UPSI. I hope that clarifies.
Moini, Tarak is asking one question, so you give him directly to him. Okay.
Right.
Moini will send you the reply because time is short. So friends, the clear message from all these speakers and the questions which we have received, that there is a confusion. Confusion is on various aspects, on the basis of health issues, on the basis of transaction starting point of view, on the basis of the transaction which is starting, corporate action which is starting and it is finishing. So many issues are there. As SEBI is coming out FAQ on various things, these things should also come out, so there should be any clarity. And then one more thing, you cannot give answer of each and every query. There should be principle you should plan. What Ravi has said, 3 point of principle, that principle SEBI should also give example as well as the principle they should narrate. So anybody who is in trouble, he can read it. And then they should also give the governance principle also, because somebody has asked questions of the 999 crore rupees, whether it's a governance or not. So sometime if you are making a law, you can't govern. So it means 1 crore rupees is also governance point of view. So we have to be very, very critical and crystal clear that what is the law and how we have to move it. So thank you very much. Thank all participants for participating in this. Thanks all my learned speakers. As our journey will continue, our 96th webinar is on corporate fraud. And friends, we are covering on type of corporate fraud, regulatory framework of corporate fraud, consequences of corporate fraud, tools to detect corporate fraud, including forensic audit, how to prevent from corporate fraud. And very interestingly, we have invited Mr. Krishna. He has he's an IPS officer and he has done investigation of Satyam, and he has come out so many things. He was in CBI. Mr. Rajiv Sharma, ex-joint director of CBI, presently is ADJ in Jaipur, Rajasthan. And then Mr. B.A. Sundaresan, he is the executive director, and forensic expert, Mr. Naval, Amit Khemka, Ashwini Taneja, Ravi, Prakash, and other people. And we have invited Rakesh Asthana, Commissioner of Delhi Police. He has handled so many things. And so this topic will be a very interesting topic. I request all of you, please participate in corporate fraud, which will be the next webinar on 22nd July. Till then, thank you very much. Good night.
Thank you.
Thank you so much.